start off by telling you who the Texas Judicial Commission is, just in case you're new to us. Okay, so this is a photo of the day in 2018 that both high courts sat and heard all-day testimony from people in your shoes. So they were professionals in the mental health law systems. Attorneys, judges, psychiatrists, psychologists, people with lived experience, law enforcement, told the highest court judges what was really going on in the trenches, how we needed more coordination, how we needed more support, and how the idea of a judicial commission on mental health was a good one. So from that hearing, we launched this judicial commission with the mission that you see there, but our focus is ultimately to improve the lives of the people coming through our courts, and especially those with either mental illness, intellectual or developmental disability, or substance use disorders. And we do that through 3 different strategies. So we focus on collaboration, education, and leadership. So collaboration is just how this whole commission is created. We have representatives from all of those professions that you see listed. We want to hear those voices. And when it's time to, say, work on legislation, we have a legislative research committee. So when we sit down and say, what needs to be changed in this system, then we look at all those stakeholders to tell us what's going wrong. And we don't always agree. And so that's fine. This is a space to talk about that and work it out. Another part of our mission is to educate. So if you're not familiar with our bench books, we have an adult bench book in the darker green and a juvenile bench book. And they are just packed full of information. We have the authors for the main part of both those books on the call, Molly Davis with the juvenile and Kama Harris on the adult bench book. It's been a collaborative effort, but they have certainly steered the ships on those. So those are online if you want to look on our website. And we also have hard copies that you can request for free. Okay, and under leadership, we especially work with our judicial leaders to try to get them to be the champions, because we know when judges call meetings that people come. Okay, so big picture, 3 parts to involuntary commitment. Sometimes it's called civil commitment. You can see the slide corrected itself because in Texas, it's actually called court-ordered mental health services. So emergency detention is the first step. It is when someone's in crisis and we need to get them to the hospital so that they can be examined to determine what's next. It's also a good time for stabilization. The protective custody is that in-between step when you have them there and you are filing for your court-ordered mental health services. It's a safe place for them to be while we're getting to that final step. And of course, you don't have to go through that. If someone is out in the community, you can apply for court-ordered mental health services. But this application will determine if they're going to be inpatient, outpatient, if it's going to be temporary or extended. And we'll hear a little bit more about that later. All right, so I'm going to move quickly through these because a lot of people had familiarity. But if you think about the emergency detention is detaining someone who is in a severe crisis. And it is, again, just for that preliminary examination and to stabilize them. There is some discussion right now about that criteria and whether we should change that. It's hotly debated, right? Because people that are very concerned about civil liberties don't want to make it easier to commit people. But a lot of families come and say it's too difficult. We have a mentally ill family member and we cannot get them picked up because the criteria are either too difficult or they're read in a very stringent way. So the purpose is to keep them from harming themselves, get them to a facility, and get treatment started. But we do want to remember that we're always trying to place in the least restrictive, most appropriate setting. It actually says this in the Health and Safety Code. The types of emergency detention, all of the counties seem to do this in different ways, but the statute provides that you can do it with a warrant. You have to have a doctor, a licensed mental health professional that is employed by the LMHA to help start this process. It's something we just changed in our legislative session through the JCMH work this last session, because some of our rural counties said we don't always have a doctor there to start the emergency detention. And then, of course, I know Travis County only does this through peace officers. There's also a third way through guardians, but it is very rarely used. Okay, I'm going to move through these quickly. I will just let you know that Brilliant Kama Harris has taken the time to create step-by-step charts on what to do. All right, so here is our step-by-step chart on emergency detention with a warrant. And here is our step-by-step chart without a warrant. So it is here. We wanted to provide this for you. And this is a slide to show you how they come together. Some of our counties, it's interesting, the more rural counties said that they have both and that their judges hear emergency detentions 24/7. So I'm thinking that's JPs that are already doing inquest duty. And so they are just on duty 24/7. But we had a emergency detention roundtable to talk about the different issues that came up. What we found is this chart here. Well, we made this chart from our findings, that there were some counties in the red. I don't think anybody on this call is like this, but we did talk to some counties that said none of our judges will hear emergency detention warrants. They don't feel qualified, different issues. Like there's not a hospital in our county, so they think it's better for the county that has the hospital to do it. And our law enforcement do not do the warrantless type. And so obviously that's not preferable, that you have no access to emergency detention. The yellow is when you have more of the limited access. And we do hear some concerns about this, because if you are only relying on your judges and they're not open on the weekend and you have no law enforcement participating, then you can see that causes some crisis situations. And then we have lots of combinations of all of these. So it's something to think about. If your law enforcement is not doing isn't doing warrantless emergency detention, do we know why? I think that combining these two different entities really offers the most coverage. And maybe, we've been to teach in different parts of the state where they said they don't know that they can do it. Maybe it's a policy decision within their law enforcement. But again, this sort of county mental health law plan where everyone sits down to talk about it could be the opportunity to point out this opportunity for law enforcement to get involved, or for our JPs or magistrates, whoever is issuing your emergency detentions, if they do not feel qualified. But what I did find very interesting is that no one is really in charge of checking this. Maybe in El Paso, I know you have an administrative judge. Maybe you feel like as the administrative judge, this is something you could look into. But in the majority of counties that we've talked to, no one really had direct statutory authority unless it was, given within your county, like an administrative judge. So I do think it's important to look at, because I think it could be falling between the cracks if it's not, if it's assigned to everyone, then it's assigned to no one, right?
The next slide moves on to OPCs.
Okay, great. Well, then let's stop right there. And first, can we have our guest speakers introduce themselves briefly?
Hi, everyone. I'm Daniela Chisholm. I'm the senior trial attorney at the El Paso County Attorney's Office in the Mental Health Litigation Unit. Michael and myself, we take care of the involuntary commitments. We also train our local law enforcement, partner with the hospitals to train them on the involuntary commitment process, and are involved in the AOT assisted outpatient treatment program. Prior to this, I was a defense attorney. On the other side, I represented the ad litem, those individuals going through the commitment process, and have joined the county attorney's office and had the pleasure to work with Michael and the office here.
And hello, everyone. I'm excited to be working or be part of this collaborative effort. My name is Michael Gomez. I oversee the county's mental health litigation unit. And like Daniela said, we pretty much handle all things mental health related. But more importantly, I think that something that we try to do in our unit is we try to instill this culture, promote this culture where we talk about therapeutic jurisprudence. And that is where we use the law to help those individuals with mental health issues or mental health needs receive those services through innovative approaches, not just as our typical roles as prosecutors, but, come up with ways like this collaborative effort, for example, AOT, which we'll talk about a little bit later, and find out ways on how we can help out, the community, as a mental health advocate more than anything. And I see our county attorney is there on the screen, it's Joanne Bernal, and really all of this is possible in a collaborative effort, because of her, so, thank you.
Thank you. Well, if no one has any questions, I'll just throw out a couple of the common questions that we see. So Michael and Daniela, how do you work with doctors who are hesitant to testify, that they don't want to get involved?
So a lot of what we do is handling things up front. So we do a lot of trainings and engaging with our physicians here in El Paso. That means trainings to get them to a point where they feel comfortable and confident about the process, and have us as a resource as well. So a lot of it is explaining, hey, look, if we can train you and get you taking care of things up front while you're filling out the documents, you understand the legal processes, you won't have to worry so much about when it comes to testifying or be called in court, because already the documentation is going to speak for itself. And then if there's needed testimony later on, you're going to be feel empowered and ready to do it. So a lot of it is a lot of preparation that we do and partnering with our physicians.
And I think the key thing here is having an open line of communication with our office. The doctors literally call us or text us, hey, what do you think about this? What's going on with this? 24/7, open line of communication, and the training goes as basic as doing mock trial training. We actually host mock trials with them, where we put a witness, we have a pretend judge, we have a pretend defense attorney, and really go through the whole process of what they can expect in court. So once they're there, they're not scared or intimidated by the whole process.
And I think a lot of it is once we break down the process and answer their questions, so they feel confident, a lot of the worry seems to kind of cease, and they're able to be able to focus on what it is they're trying to do, which is to get this person help. So I think a lot of it is the education and just relieving some of that stress they may be having.
Just one thing I want to add to that, and really this is something that is key to El Paso, why things work so well here. It is really a collaborative effort. I mean, really, our mental health stakeholders, from police to the hospitals to the judges, to the allied items. I mean, we all agree that we are all on the same page, and we're all trying to help these individuals with mental health needs. It's not in a sense adversarial, in the sense that we want to win a case per se, or the defense attorney wants to win a case. We're all just looking for the best approach to help these individuals. So here in El Paso, we're not necessarily in the business of like committing the individuals. We just try to link them up with the services. Commitment oftentimes is more of the last resort.
Are these trainings or mock trials that you hold in your office, and I assume you invite all the stakeholders? Because in El Paso, law enforcement also does warrantless, correct?
Correct. So normally what we do is we go out to the facilities, each individual facility, and train them independently and kind of tailor it to their needs and their concerns. We also work in conjunction with our medical school. We have here a psychiatry residency program, and we take them from when they're coming in into their orientation to start explaining the law then, and moving them through the different stages, so that once they sit down and they're filling out the documents, they know what's going on. And then I think really key is, again, just having access to a resource. It's really hard to take in all the information at one time, to know that to make that partnership as a continued resource, so they can not just feel we're in there for that one training and out, that they can lean on us for different issues that do come up.
Great. So the same idea with law enforcement, that you have that program running, but I know there are a couple of communities here that law enforcement at this time is not doing warrantless emergency detention. So you could walk through, I guess you would do the same sort of process, is go meet with them and answer questions and share the law.
Absolutely. Same process.
Yes. And we try to do that. We reach out to our law enforcement agencies, and especially for new recruits. Every time there's a new recruit, so every year we train them. We give them the ins and outs of the EDO process. And I know there's a different acronym, APAL, that you all use. We say notifications of detentions here in El Paso. But basically, we train them the ins and outs, the legalities, and also meet with our counterparts, the city attorneys, to address any concerns that they may have, for example, regarding their law enforcement agency. And so again, key component is the collaboration and open line of communication. OPCs, we call them PCOs, but it's the acronym's interchangeable. Excuse me if I say PCO, I mean the same thing. I'm getting used to saying OPC. But what it is, it's basically what Chrissy said, it's the in-between stage between the EDO and the actual final commitment. And so realistically, I'm trying to explain it in layman's terms, what happens is you have an individual that undergoes a mental health crisis. That person is taken to a hospital. The hospital then has 48 hours to evaluate or release. After making a determination, if the hospital wishes to keep the patient there at the facility a little bit longer, what they need to do is file an application for temporary or extended inpatient mental health services. Along with that, there will usually be an application for an OPC or PCO. And what it is, it's telling the court, hey, court, listen, this individual is such bad shape that we really need these types of psychiatric services. Can you please give us a hearing? Because this is like any other lawsuit, there will be a hearing, but it's not going to be, within the next 3 days or so. You'll probably get a hearing, a week out, 2 weeks out. And what happens realistically is that that individual needs somewhere to stay. Otherwise, he would not be in the hospital. So the OPC or the PCO is a mechanism that allows the hospital to keep that patient in the facility until there's an actual hearing on the merits on the commitment. Now, the way that it gets granted, generally, it is the judge is going to review the application along with this document called the CME, Certificate of Medical Examination, which will lay out the reasons that this person is likely to be at risk of harm to self or others as a result of a mental illness. What will happen then after reviewing the application, the judge will make a preliminary determination and say, yes, you know what, this patient needs help, but I'm going to need to actually hear the merits on your PCO within the next 72 hours so we can determine whether or not there's enough, and actually standards probable cause, whether or not there's probable cause to believe that this person is suffering from mental illness and is at substantial risk of harm to self or others. In El Paso, the way that we do it is we have mental health court every Monday and Thursday. So depending on what day the EDO was processed and the PCO was processed, your court hearing will your PC hearing will be on a Monday, and your final hearing will be on a Thursday, or your PC hearing will be on a Thursday, final hearing on a Monday. So that way we always have that 72-hour coverage taken care of. Of course, the law does provide that exception when there are holidays and whatnot. And so occasionally we will have maybe court on a Tuesday and a Thursday or on a Friday and a Monday, but we are covered. So generally it's every Monday and Thursday. And we have court either one of our psychiatric facilities or via Zoom. It just depends on the judge and what's going on. After the PC gets granted originally, what will happen then is that the court will hear the case at the PC hearing. And generally, let me go back a little. Okay, so at the PC hearing, what will happen is the judge may or may not hear testimony because the law allows the court to make a determination on the certificate of medical examination alone, which is one of the reasons that we really train our hospitals and our physicians to write well. And so if the court hears testimony or rules on the certificate of medical examination that there's enough, then the patient will be detained at the facility up until the final hearing. There needs to be a final hearing within 30 days. In the alternative, if the judge believes that that there's not enough probable cause to keep the patient will be released. Technically, you still have a final hearing. Realistically, though, common sense tells us if you cannot meet the probable cause, you're probably not going to be able to meet that clear and convincing standard for the final hearing. So most likely than not, if you don't meet the PC, that PC will be dismissed. And I see there's a question about the deterioration piece. Yes, absolutely. You're absolutely right. Generally, I feel that at least in El Paso, we believe that deterioration is a risk of harm to self. So we kind of just put it in there. But you're right. There is that deterioration, third component, risk of harm to self, risk to others, or that deterioration language. We argue that the deterioration is an obvious risk of harm to self. But yeah, you're right. If the PC is granted, like I said, in El Paso, we will have a final hearing the following court day, which will be Monday or Thursday. Yes, and and I see that question that some of the hospitals disagree, and that's right. I mean, we have the same here. Some of our law enforcement disagrees, some of the hospitals disagree, but it's just a matter of an argument, and ultimately it's up to the judge, right? We can only say as much, and the judge is ultimately the person that's gonna make the determination. At the final hearing, we do need a second certificate of medical examination. Now, the law does say that there must be, the second certificate of medical examination must be prepared by a psychiatrist if one is available in your county. Strangely enough, there is no definition for psychiatrists. We do have a case pending in the Supreme Court right now that talks about the possible definition of psychiatrist, which was argued maybe about 3 months ago, so we should be seeing something there. But as of right now, we do not have a definition for what psychiatrist is or what the meaning of availability means in any event. So it'll be interesting to find out what the Supreme Court thinks about that. That definition of the administrative code, that is the argument that we've always made to our probate courts, and our probate courts did agree. Our 8th Court of Appeals disagreed. That is essentially the definition that we're trying to push to the Supreme Court. And we're making arguments why that should be the definition. But in essence, the Texas Administrative Code definition, what the judges did say, or at least our panel, the appellate court panel, was that was limited to the prescription of psychotropic medications, almost in a sense that it was very narrowly tailored to be applicable only when giving medications. And strangely enough, the law, when you're giving medications, the law does not require a psychiatric or a psychiatrist to submit that application. It only requires a physician. So it seems to be at odds with what I was saying, and we're hoping the Supreme Court will essentially fix all that. So at your final hearing, we call that, with your application for the temporary or extended inpatient mental health services, you must prove through an expert witness, again, that there is clear and convincing evidence that the patient is suffering from a mental illness, and that as a result of a mental illness, the patient's at risk of harm to self or others, or that deterioration language. The law, generally, your physician that does the CME will be your expert witness, but there's no requirement that it be that physician. Also, there is case law, at least out of the 8th Court of Appeals, that says that medical residents do qualify as experts. So we are glad, at least here in El Paso, that we can use our Texas Tech residents that focus on psychiatry to use some of those CMEs and also provide testimony.
Who supplies the psychiatrist, the hospital or the county? And who pays the psychiatrist to do the CME?
So when you say psychiatrist, are you actually talking about that second psychiatrist requirement? Because that's a little bit tricky. If there's none, that's part of the argument that was made to the Supreme Court. Like, how do you determine availability? Can you force a psychiatrist to do a CME? I don't know that you necessarily can. Here in El Paso, the facility that's going to be the committing facility generally provides all the CMEs. Yes, only one is psychiatrist, the other is any type of physician. That is correct. Here in El Paso, what'll happen is, well, we have this MOU where pretty much any health facility is considered a mental health facility. But for the most part, hospitals that don't have a psychiatric inpatient facility will not move forward in the commitments. And so what ends up happening here is that the patients can remain at a hospital for, I don't know, a week or so, and they're eventually transferred to psychiatric facilities. Because again, we're not necessarily in the business of committing individuals. Our patient population for the vast majority does not get committed. To give you sort of a day-to-day what our typical doctor would look like, we will have this individual come on an EDO. Hospital will then submit for an application for temporary inpatient mental health services, depending on the hospital, if it's a psychiatric hospital or depending if it's just your general hospital. The process may vary a little bit differently. Assuming that it's just your general hospital, what would happen is they will be in contact with our local mental health authority about getting space or a bed for this individual at one of our 3 psychiatric hospitals. There's generally a waiting line in all the hospitals, and the judges and the ad litems, and everybody knows sort of where everybody is in the waiting line. And we try to move and make it easier for that individual to get a bed at one of the psychiatric facilities. Once they're at the psychiatric facility, and even there while at the hospital, the patient will generally be taking medications of some sort. So the patient is in theory, supposed to be getting better once the patient is stabilized. If the patient does get stabilized within the 30 days, then what'll end up happening is that the patient will be released. If the patient is not getting better, is not taking medications, that is when we try to do the forced medications. And we'll talk a little bit about that towards the end of our presentation. But the reason I'm telling you all this is because it's relevant in the sense that whoever initiates it doesn't really matter who initiates the EDO or the application. Ultimately, the hospital that provides the psychiatrist or the CME is usually going to be one of the psychiatric facilities. I'd be lying if I tell you who exactly pays for it. I'm almost certain that our county pays for it because there's something in the statute. I don't write off the check, so it would be hard to say, but I can definitely find out. I recall reading something about that where the county is the one responsible as long as it's not a private facility. Even then, when it's a private facility, there are some mechanisms to it. The patient, so there's a question of what happens to the patient, well, until you get the hospital bed. So the patient is still being treated just in the general hospital. The patient is being looked after, and our general turnaround time, I want to say it's not longer than a week.
Okay, another question. You said your turnover is about a week, so that would fall within the statutory requirements. But what if they don't get a bed in that time?
Actually, this has not happened. Now that you're mentioning it, I don't think this has happened since that 8th Court of Appeals opinion came down. Because what used to be, we used to have the residents from those general hospitals be the psychiatrists for the second facility. Now that they are no longer psychiatrists, we had not run into this problem yet. I can tell you that what would probably happen is I would probably contact our local psychiatric center and ask one of the psychiatrists to do a second CME. Ultimately, the understanding is that wherever the patient is, we would get him transferred regardless to that psychiatric center. So even if the patient is committed at the general hospital, the order would reflect something to the effect of to be transferred upon the availability of a bed at the El Paso Psychiatric Center.
Were they trying to push for mid-level providers to complete the OPC?
Realistically, because we also tried to get a legislative definition for the term psychiatrist. In doing so, we did meet with TMA, THA, and it looks like everybody was on board with this definition, and it looks like we thought it was going to pass. We just ran out of time. And we're hopeful that by the next legislative session, we can get the same definition passed. But in any event, I can tell you that when we're talking to TMA and THA, at least the people that I talked to were not on board with having nurse practitioners be sort of the psychiatrist in that respect, or be able to do CMEs. I can tell you that other states, other jurisdictions do allow for any local any mental health provider or non-physician mental health provider to do their CMEs, and it seems to be working fine.
Okay, so we have comments that the nearest facility is an hour and a half away.
Yeah, that is challenging. I know, for example, we do have so we do get patients here from some of our neighboring counties. And we also, because we're a border town both ways, we have New Mexico and we also have Mexico. We do get patients from both of those jurisdictions as well. I can't tell you how exactly they end up here. But I mean, it's just they arrive at the hospital, and you should know our applicants for the commitments are the hospital. So it's not us. We don't apply. We just represent the state of Texas. The facilities are the ones that apply for the actual the commitments.
One point I wanted to make is I know we ran into this before, that if for some reason you don't get the OPC done, that you cannot do back-to-back emergency detentions on the same set of facts.
Unless there's new conduct, there's new information, then you can file a second emergency detention order. Otherwise, you cannot double dip on the same information for the EDO.
And we do train our facilities with that, and we do tell all our facilities that the judges really do frown upon. By that same token, you can't really forum shop either. Like if we allow our probate judges screen from 8 to about 1-ish, 3-ish business days, and then the magistrate screens the rest of the time, including after hours and weekends. But if a probate judge denies, for example, one of the documents, you can then bring in that same document to a magistrate. So we do train them with that stuff.
Christy, I think this might be a good segue if there's no further questions on this, kind of getting into AOT.
Right.
So AOT is assisted outpatient treatment, and one of the ways that we find ourselves into AOT is when individuals in the facility, they do have a commitment for that 45 or 90-day period. At some point, they're stabilized and they're ready to return to the community. One of the options we look at is for an outpatient setting, outpatient court order treatment. One tool that's becoming more and more popular, and I think more well-known around our state of Texas, and hopefully is gonna, become even more popular, is this assisted outpatient treatment. It's a very, very wonderful tool that we can use at all stages of our legal process to help an individual who does have a mental illness diagnosis or suffering from mental illness to stay in the community under an outpatient court order and have a wraparound support services through the local mental health authority, to include a judge giving what's called the black robe effect. And so what it does is we really try to pull the individuals who have been stuck in that revolving door of the inpatient system. They get out, discharged to outpatient, and then back over into the inpatient setting again. Help individuals stay in the community and be able to come little by little empowered and wanting to take participation in their mental health wellness, and begin a relationship of changing the judicial system as being something that is punishing or scary into what Michael had mentioned previously, into this therapeutic jurisprudence, where the legal system can now provide and participate in the healing or the wellness of an individual rather than to their detriment or harming them. Because as you know, a lot of times when someone does have a mental illness or a mental health condition, they have had contact with the criminal system in some form. And there are issues that have resolved, whether it's traumas from this being in the system. So this tool gives a fresh way of an individual to be able to interact with the legal system. And a key component of that is having a judicial component. It doesn't have to, but that is one of the ways that helps to make it successful. And what we have here in El Paso, I'll just speak to the program we have here. And I visited with AOT programs across the country, working with a different organization, is that the idea is just to get it started. You don't have to have the dream team right away. But if you can have at least a couple stakeholders who are interested in at least exploring this tool as a way to keep people out of the jails, out of our psychiatric hospitals, and giving them an opportunity to be empowered and taking care of their own mental illness, and their family members have support as well, then you can begin to grow the team. I think some key components that we have is to have a local mental health authority in a part of this, so they can provide the care, the social workers, the case managers, the psychiatrists, for the medication managers or nurse practitioner. The county attorney is another stakeholder. They need to have an attorney ad litem to represent them because they are under a court commitment. And in addition, we have a judge that is able to provide that black robe effect in a compassionate, therapeutic way to engage and involve with the participants. And through this program, actually, my judge, or our judge for our AOT program, is present today, Judge Strelitz, a wonderful judge that has helped many people who have gone through this program here in El Paso, have been running for 2 years, to break that cycle of inpatient to outpatient. And really, we've seen just such a wonderful success in the hardest cases of individuals who have now repaired relationships with their family members, are working, have had no contact with the criminal justice system, have not returned to the inpatient setting, and so far as where they've gone on to become peer support specialists, to have them come back and be part of the AOT program. So with this being said, getting something started and then growing it is the idea. You don't have to have a perfect system to get it running. There's a lot of trial and error, and a lot of it's going to be what is relevant to your community and to your stakeholders that you can secure, and to begin to grow the program. And I think, Kimba, on the next slide, there's some resources for AOT that are really wonderful. But these two are wonderful resources. The Texas AOT Practitioner's Guide is broken down from A to Z, how to begin the program, and walk you through what legal steps you'll need as far as having the commitment in place. And then what's referred to as the white paper, the implemented building blocks, goes through and, what stakeholders do you go after? What are the reasons for having an AOT program? What is the goal, the purpose? And these two resources are really wonderful if you're able to take a look at them. I'm just gonna reference the questions real quick. So right now, I believe my judge answered this question for everyone, but I believe we have 33 participants as of yesterday. For AOT here in El Paso County, we meet weekly. Every Thursday from 3 o'clock to 5 o'clock, we meet over at one of the offices for our local mental health authority. About 10 participants come in to meet with our judge. The real focus is the judge and the participant having the opportunity to make that connection, to be able to work through whatever's happening in that individual's life so that the judge can help to guide the rest of the team. How can we assist, and whether it's for the case manager to work with a job, or the family needs resources to an organization like NAMI. And really, it's wonderful to see what happens when that trust and relationship begins to build between the participant and the judge. The question here is, as AOT appropriator used for clients with aggressive offenses. So each program can develop, as it's a new program, can really develop and tailor and start how they want to start. Maybe starting with some quote easier cases as well to get their the feet wet, to see how it's going to go and how the process runs. But as a program continues to grow and you're more familiar with what your case managers can handle, what the judge is able to relate to, you can begin to take a little bit more challenging cases. For example, we've had participants that have had companion criminal cases at the same time while they're in the AOT program. Part of what we can offer in the AOT program is that the ad litem that's appointed to represent them can work with the criminal defense attorney to say, hey, our mutual client is in this wonderful program. They've been doing well. Our program manager provides a report to the ad litem to give over to the criminal attorney to say, hey, this is where the individual really needs to be. They're monitored, they're engaged, they're doing well. And we have seen some cases have been dismissed, or there's been a reduction in the offense based on their performance in the AOT program. Generally, an individual is in the program for about 1 to 2 years. It is really neat to see that while an individual may come in, it is an involuntary court commitment. This is not a voluntary program. It's under a court commitment, that after that first 90-day period that they're in, or that first commitment order they're in, people start to want to be in the program. So while we continue to renew their commitments here in El Paso every 90 days, we do get a buy-in from the participants, and they do want to continue. So there is an understanding you're still on a court order, but it is very important that we empower that participant when we're having the court hearing to renew them. Yes, I do want to keep participating in the program. And that's part of their healing and them being able to empower and be part of their own wellness journey. Do we have a threshold of how many people can be served at one time? So we do bump into having a limit of how many people we can take at the moment. Our goal is to continue to expand the program as it does well, but we do bounce against that because the program is tailored for such high interaction with the participants. Each case manager can really effectively have about 13 to 15 clients on their caseload to really be able to give that level of care that is what we want for AOT. But the goal is to continue to grow the programs and integrate them into other areas of the law.
Daniela, can I add in that I know sometimes there's criticism that it's a low number of people that's being served, but I think that also pairs well when we look at the faces that we see over and over again, that if you can put those folks into the program, how the multiplier is great.
Absolutely. That would be somebody who is seen on a weekly basis, who they get stabilized and then stop their medications, decompensate very quickly. And then, we're seeing them on a Monday and they were discharged on a Friday or something like that. So I think and that's what we're focusing more on now, is really finding those difficult or challenging cases, not an individual is challenging, but there's someone who is having a challenge having so much contact with the system and saying, hey, can we try this? And can we give all of this to this individual to really minimize the contact they're having with our system? For the question, if someone decompensates post-graduation, can they easily move back into the program? The answer is yes. We generally have had the graduates have had wonderful success where we haven't seen them again, but we have had a couple individuals that have graduated and we've invited them back into the program. For whatever reason, that's how it is with mental health. This is a spectrum. Sometimes it's easy to be balanced and stable on your medications and engage, and other times life presents other circumstances and people find themselves needing help again. The idea of this program is not to punish somebody. It is, hey, you had a crisis, you're having a difficult time, you think our resources could be used again, or the facility is recommending it, we will welcome somebody back into the program. Along with that, if someone doesn't really get kicked out of the program or punished, if they miss their medications or if they miss seeing the judge, we want to know what's happening behind the scenes. Why is this happening? So that we can help. Is it a lot of times it could be as simple as transportation, or they don't have the pill box, or whatever it is. Very simple solutions to problems that look like someone is not complying to a program. So we really shift a perspective here to kind of getting into the eyes of the participant. How can we help you so that you can succeed? And the question for how long the program is, it can be dependent on how you set up your program. Statistics we have, the information we have is usually about a year is when someone has enough time to start to not just get their basic needs met, the housing, the social security, the insurance, but start to have real goals and be able to achieve some of those goals, to create a relationship with the team and to find some trust in the system again. So we do have had participants that haven't wanted to leave. They get to the 2-year mark and they really don't want to graduate, and unfortunately have to, kindly tell them you're ready and you're ready to go to a lower level of care. And that's ultimately what we do. Once an individual does reach that level of stabilization, they feel good, the team feels good. We have a graduation ceremony for them to congratulate them, to go over some of the things that they've achieved in the program, and then graduate them to a lower level of care where they're no longer needing to be on our core commitments. Do we serve persons with IDD? So we do have some individuals that do have a dual diagnosis where they do have a mental illness diagnosis and IDD. However, we tend to see that the services we have here, at least in El Paso for IDD, are a little bit more appropriate for those cases specifically. They seem to have a little bit more resources than what we can offer with just AOT, but we do have some individuals that have both, and that's not necessarily a deciding factor to not have them in the program. Do you have anything you'd like to add about AOT, Michael?
It's a great program, and honestly, one of the best things to look forward to is somebody graduating. A lot of these individuals have never had a pat on the back. And just the simple fact that the judge is handing them a certificate and a piece of cake, just gives them an incentive to just do so much better, because they've probably been, told time after time that they're doing something wrong, getting punished, being in jail. And so you're creating this new trust for them through the judges that is just life-changing for them. Really is life-changing. With very specifically for some of the cases that we've seen here, I can tell you that there's been, individuals that were being charged with multiple counts of felony arson and did not have relationships with their family, did not talk to their children. And, 2 years later, they are serving as role models for the AOT program as, what do we call them, communities? Or we want to make them a
Peer support specialist.
peer support specialist.
Yeah.
And so, it's just a great program. I am a firm believer of the, on this program. What we can do better, since we're talking about funding, Christy's here, funding is always the issue, I think, with any of our programs, and I think that's the one thing that we would love to get more of.
And just to follow up, although we have a very active judge in our AOT program, but it doesn't necessarily, that's not one size fits all. If you have a judge that's interested and willing to at least hear the cases and do the legal part of it, and then you can build your team around that, that's a perfectly fine way of doing it. Of course, the more engaged you can have your stakeholders and your judge in this, that's wonderful, but it doesn't have to be that. And this is something that can really be tailored specifically to your community and to the needs of your community. There was a question if AOT program provides housing. At this time, we don't provide housing through the AOT program, but we do link them with another program that can assist them in providing housing.
For new programs, I was going to mention there are SAMHSA grants that are about to be released, the request for applications. Danielle and I are both working with the Treatment Advocacy Center, and they've been sharing some of that information, but I think that is for new programs, I believe.
Yes. And just, but one thing I'll just final add on AOT is that when I made contact with AOT program, I was a defense attorney. I was representing the participants going through the program. And when the judges approached me to, you know, hey, they're going to be in this year-long program, I thought, no way. I'm really concerned about what's going to happen, the legal processes of these, my clients' rights. And it only took about, I guess, 2 months until I saw the change in the client, some of my most difficult cases that I had been seeing contact with this system transforming in front of my eyes. And as a defense attorney, I didn't want to be a barrier to this individual getting help by trying to zealously advocate for something that was really assisting my client. And so I had to get out of the way as a defense attorney and do my role and assist my client in every capacity that I needed. But I didn't want to be a barrier any longer for this person becoming well and making these connections and becoming empowered. And it just really transformed me. So big believer in this program and happy to help anybody that has an existing program or maybe interested in getting started with an AOT program.
Involuntary medication is a complicated, often misunderstood process. So we will be very high level here, but hopefully we can have more of this great discussion and question.
For psychotropic medications, at least how we do it in El Paso, as stated before, we don't really commit individuals, and the only way that you can get someone on forced medications is through an inpatient commitment. Okay, so it's not even an outpatient commitment as well. So it's only inpatient commitments, and also under 46B of the Code of Criminal Procedure. I'm going to focus more on the civil forced medications and talk briefly about 46B, just because we do handle those 46B, but they're initiated through our district attorney's office and through the criminal court judge, and we just sort of get called on to essentially just handle the hearing. So we don't initiate none of the paperwork there, but essentially it's the same thing. Practically speaking, in El Paso, we only do forced medications on those individuals that have these types of mental illnesses that get progressively worse as time goes by without their medications. Generally illnesses like schizophrenia, something that along those lines, schizoaffective disorder, that the longer they go without medication, their baseline is getting progressively worse. And what I mean by baseline, for those of you that don't know, is generally, I mean, I'm just gonna say we start at 100%. I doubt that any of us are 100% ever, but let's, for this example, let's assume that we're all started at 100%, and the longer, and then you have your mental health crisis, so that 100 goes down to 95. And now that you're at 95, you can never go back to 100. And as soon as you're at 95 and you stop taking medication, you go at 93, 90, 80. And so you really need to stop that ASAP. The only way you can stop that ASAP is through a commitment, because that's the only way you get the forced medication. So that would be the times that we do those forced medications and the commitments. And the way that it's done here in El Paso, we generally do them at the same time that we do our commitments. So we'll file an application for inpatient mental health services along with that application for forced medications. How it happens procedurally at the courtroom, it's a little bit different depending on who the judge is, but it's always going to be the same thing. You hear testimony on the commitment, and then after the commitment is granted, then you put on testimony, assuming the commitment is granted, you put on testimony on the psychotropic medications. With psychotropic medications, it's a lot more formulaic, I would say. There's not much room for argument, because what's required more than anything is just the lack of lack of capacity for the patient to make a reasonable and well-informed decision because of the mental illness. And that is already kind of generally already determined because the judge already heard the testimony as to the risk of harm to self or others of mental illness. So it's almost like presumed. There's not much of an argument to make after that. And once the patient's committed, we focus more on the recent. So, and we look at, for guidance, we look at 574, let me see, 574, 106, subsection B, which talks about things that should be considered by the court in making the determination. You know, preferences with treatment, the likelihood that it's going to work, risks versus benefits. And it's almost like a very formulaic question. Has the patient expressed a reason for refusing to take medications? Yes. Is a bit or no? What's the reason for refusal? Whatever the reason is. Has the patient expressed a reasonable alternative that would work for medications? No. Yes. I mean, you just go really down the line and ask about the risks, you ask about the benefits, whether it's going to help out the patient's psychiatric condition, and then just sort of rest. Like I said, it's more formulaic more than anything. I think it just sounds intimidating just because of the very nature of the beast, but it's really not. I think once you train your physicians, because they're going to be the ones testifying, unlike commitments, you don't need a psychiatrist. It's just your run-of-the-mill physician, and technically under definition of physician, it could be a resident as long as there's a physician in training permanent in place. So it does make it easy for you to go forward on for psychotropic medications. The one thing to recognize though is that it's only for psychotropic medication. So occasionally what we'll have is this patient that's diabetic, right, and is refusing to take insulin or refusing to take something, and the doctors are saying, well, you know, he needs to take that, he's going to die. And, you know, that is one of the challenges that we often face. Or you know, one time we had a patient that was refusing just to eat. And ultimately, I mean, the thing that we can hope for is that through the administration of psychotropic medications, that the patient eventually is going to regain some insight, have a little bit of a better understanding as to the importance of their, I guess, physical manifestation of illnesses, right? Diabetes, heart conditions, kidney conditions, etc. And I don't think that we've ever run into something where, you know, the diabetes caused something worse than it could have. For the most part, I think we've been fortunate enough that the psychotropic medications do create some understanding of the patients. By the same token, sometimes we get patients that are very ill physically. And unfortunately, those patients remain at the actual hospital, and we can't really treat them for the psychotropic medications or for the psychotropic illnesses until they get better and are released from the general hospital. So we do have those issues as well. With regards to 46B, it's almost identical. The questions are the same: risk versus benefit, reasons for refusal. I think it probably may be a little bit easier because it just requires at the same time that they just be incarcerated and pending trial, and I forget the exact same verbiage, but it's a little bit easier, I think, but the process is ultimately the same. Is there any question? Oh, I'm sorry.
I just wanted to follow up on, while it is a very formulaic process that we're going through, making sure we're covering what we need to cover in the law, going along with a lot of times people are coming in, maybe especially now, their first time going through a commitment process or being asked to take medication, psychotropic medications, and they'll refuse and refuse. Part of what we try to do, and the judges are really good about, is having an admonishment of the individual to say, hey, here's what the doctors are recommending. This is why they're recommending it. You know, will you agree to take it? We can continue the case to see if there's an opportunity for that. You know, after having a more official explanation coming from a judge, is there an opportunity for you to take another route rather than having to go forward with this forced order for psychotropic medications? And sometimes that is an option that allows for us to not have to proceed forward. Of course, if it's necessary and it's at that point, we need to go forward. But there are ways to work within, as the attorneys, the judge, the ad litem, to see what is possible, that maybe it's just a matter of having the judge admonish the individual first and not needing to proceed forward with that application.
I just wanted to clarify that at the competency restoration class, we are going to go into the court-ordered med process for 46B in detail, but this is really where it starts. And so we thought laying out the foundation here would be really helpful, because I think it's confusing to criminal courts why they have to do the two-step process of going back to the probate court first. And I think that's the, US v. Cell that requires that right now. And there's some discussion about trying to work around that in different ways. But for right now, we thought we would just get this part down. So this process is really just for your inpatient patients who are refusing. And then when we get to the competency restoration and other discussions, it could be for the incarcerated who are either under a commitment or incompetent and ordered inpatient but are waiting.
The one thing I think we forgot to mention is that as soon as a patient is committed to inpatient, the law does require that the facility start looking into outpatient commitments. So as soon as a patient's an inpatient, there should be some type of effort to try to move that patient back to outpatient. This is why AOT is a great transition program, or any other outpatient service, but just another reason why to look for AOT. The other thing I just want to clarify again, I'm not sure if I said it, is once the patient's inpatient, once the patient is an outpatient, you cannot do forced medications in outpatient. But should the patient decompensate or something should happen while they're in the outpatient, on that outpatient commitment, there could be another application to modify that commitment back to inpatient. And so once a patient's back in inpatient, then you can do the psychotropic medications again.
And one thing I wanted to add that we worked on through the JCMH legislative process was that when you get that involuntary medication order, it used to not include blood draws and things to follow up to check and make sure that the patient was tolerating the medication okay, checking the liver, checking the med levels. We had probate judges coming to us and saying, you have to go back and get another order for that. And so that is something that we changed this last session, that those sort of involuntary processes are now included in the involuntary med order. Thank you, Daniela and Michael and everyone here, and we will see you on February 9th.
Thank you. Bye-bye, everyone.
Bye-bye.